Copyright in these lectures is either owned by the ANU or a third party who has licensed the ANU to use it. Students may use the recording for personal study only. No lecture may be communicated online, copied or shared without the prior permission of the ANU.
Let's make a start. So we didn't quite finish off last week's lecture, so perhaps we'll start there. Just a reminder before we do get into the lecture that the report's due this Friday, I think it's this Friday. It's this week anyway, so make sure that you've had a good crack at it by now, I hope. Look, take on board my comments last week about taxation look, the usual sort of questions coming through. Do you need to use references or do you need to include a list of references? Look, ultimately it is an academic piece of work. It's something you're doing at uni, so I think it's best if you do include a bibliography or list of references at the end of your report, but you're not going to be judged if you only cite the textbook or my lecture notes. That's absolutely fine. So I'm not doing that to say to you should be researching this thing to death. It's really just because it is an academic paper. So that's fine. What other questions have I had? About IRAC? No, you don't need to use IRAC. You can, but you don't need to. And I would say that for this one, I would say you'll struggle to meet the word limit if you do that. Can you use a table? Yes, you can, and I would encourage you to use tables. But just remember that tables on their own in isolation lose a little bit of meaning, so don't just hide things in the table. Just make sure you do actually refer to or talk to the table, is the way I often express it. I might post a bit of like a frequently asked questions on Waddle about the report. If you've got any questions, feel free to come and talk to me though. So last week we commenced our discussion of directors' duties, which I said will take up a fair part of the course, certainly a couple of weeks at least. And we talked last week about the duty of care under section 180, and then tonight we'll start the conversation about 588G, and then in the next lecture we'll move on to some of the other duties. So 588G is the duty to avoid insolvent trading, quite an important of the duties. It's a provision that protects creditors. And remember we saw in last week's tutorial, some of you may have considered 588V. We talked about it's almost like it's a way of getting around the corporate veil, because usually directors have some protection. Creditors can't just sue directors, but where they have engaged in insolvent trading, directors can become liable for the debts of the company. So it is a serious section for directors. It's something that ASIC monitors, because ASIC will often bring actions. Bearing in mind, by the time we're considering 588G, something seriously wrong has occurred. Something has seriously gone wrong with the company. Just because a company becomes insolvent doesn't mean that something has gone wrong. Doesn't mean that directors have breached any duties, but the liquidator really has an obligation to at least consider whether directors knew and when directors knew that the company was insolvent. And later in the course we'll talk a little bit more about the insolvency issue, but we'll just talk about the director's duty aspect of it tonight. So there's four things, as I've set out on that slide there, four elements to 588G, and some of you may consider this in tutorials this week. 588G, and I've highlighted them, you may pick up in the blue there, the four elements to the 588G offence. The first is that it only applies to directors. So whereas, remember, some of the other duties we've said apply to officers, and indeed section 182, 183, which we may get to tonight, apply to employees. 588G only applies to directors. But again, remember that example we looked at last week. Remember I showed the Standard Chartered Bank and Antico case. And in the Standard Chartered Bank and Antico case, a little bit complicated, that case, but if we summarise it, we could say that it was an example where a company was actually found to be operating as a shadow director of another company. And when that other company became insolvent, the directors were found to have engaged in insolvent trading, which of course meant that the shadow director was also liable, and the shadow director was that other company. So when we say directors, we apply the Section 9 definition of director, which includes de facto directors and shadow directors. So that's always going to be a significant consideration. The second element, and we'll explore these in a bit more detail, is that the company incurs a debt. And we'll look at what it means to incur a debt. The third thing is that the company is insolvent. And the fourth element there is that the directors have grounds to suspect that the company was insolvent. And there is a little bit of overlap between the third and fourth elements, but they are also quite separate things. So we need to make out all four elements. We need to satisfy all four elements there before we can say that there is insolvent trading. So we've talked about director already. That's fairly straightforward. The second element being a debt. What do we mean when we say a debt? So usually when someone says debt, that conjures up the idea that the company has borrowed money, right? They owe a debt. But for our purposes here, we take, and this was the law, this was applied in the Hawkins case there. That's where this definition comes from. The Hawkins case says, it's every week. The Hawkins case says that a debt is an obligation to pay money. So any time the company subjects itself to an unavoidable obligation to pay money. So yes, it could be that the company borrows money and says, yes, I will repay you at a certain point in time in the future, because that is an obligation to pay money. But it could also be that the company enters into a contract and agrees to purchase a particular item, particular equipment. It could be a motor car, it could be engages IT services. All of these things, the company is agreeing to pay money. So it is subjecting itself to an obligation to pay money. So so what I say is here, when we say debt, it's not just going to be entering into a loan as such. It's any obligation to pay money. And it may be instantaneous. So it may be that the company, where the agreement happens and where the obligation to pay money, there's not a lot of time difference between those. So that's quite significant. So as far as when you're dealing with this type of problem, really all you're looking for is some sort of transaction that the company enters into. If the question, alludes to insolvent trading, all you need to find then is some sort of transaction where the company has subjected itself to this obligation to pay money. It might also be a contract for services, and typically, when we think about creditors of a company, who are the typical creditors? Who are the typical unsecured creditors of a company? Typically, it's people who have done work for the company, so not so much employees, but people that have done, they've installed a new kitchen at the premises, or have done some sort of labour work, and so the company owes that person or owes that other company money. So that's an obligation to pay. The third element is that the company is insolvent, and this is always have a bit of a chuckle. What does it mean to be insolvent? Well, the question of insolvency is actually quite complex. At what point in time did the company actually become insolvent, and when did it become insolvent? Perhaps think about that the other way. When did the company become insolvent, or is the company insolvent? When did it become insolvent? So our starting point for considering whether the company is insolvent is section 95A 1 and 2, but these are a little bit tricky, or perhaps not that. I would say they're not that helpful. So subsection 1 says a person is insolvent if and only if they're able to pay all debts as and when they become due and payable. And what does subsection 2 say? It says a person who is not solvent is insolvent. So, in my view, that's not particularly helpful. The first section basically says, do you have the money in the bank to pay your debts? If you do, then you're solvent, and then if you don't, well, that's a fairly simplistic view of what it means to be solvent or insolvent. So the courts have adopted a cash flow test, and that's where it gets a little bit tricky. And so in tutorials, and if this was to come up in an exam question, you'll see something in big flashing lights, right? Like, this company has cash flow problems and is unlikely to raise capital, because companies do from time to time have some sort of cash flow issues, but companies can overcome those problems. At times they can do it fairly readily. They can go and raise capital, they can go and borrow money. So those are the simple solutions. So just because a company has cash flow doesn't necessarily mean that the company is insolvent. It needs to be something a little bit more. But if you saw that a company in a question, a tutorial question, exam question, has cash flow problems and is unable to raise capital, then I would say yes, this definitely suggests very, very strong suggestion that this company is insolvent. And so that's precisely the view that the court took in the Fryer and Powell case. It said, look, it's not just a temporary lack of liquidity. It's not just immediately the available cash resources, because if it was, and the suggestion at 95A is that means. But the courts have taken this really quite a practical view, that we have to look at what access does the company have, what ability does the company have to raise capital. That also, though, does cause problems when the question of solvency in practice is quite a significant issue. But so we'll try and keep it as simplistic as possible for our purposes today. The next aspect then to insolvency, the fourth element of the insolvent trading, is the reason to suspect insolvency. So it does sort of flow naturally from the third element there. So the fourth element there being the reason to suspect, or a reasonable person would suspect that the company is insolvent. So if we look at the Asic and Plimen case, or the Asic and Elliott case, in this case, look, I won't go through all the facts because I don't think it's particularly helpful. But in this case, the company was insolvent, so we'll just accept that as a fact. The company was insolvent and continued to trade. So it was fairly clear. So it definitely looks like insolvent trading. What was the argument that the directors ran in this case? And some of you may know that Elliott there is actually a fairly high-profile individual. Used to be the president of the Carlton Football Club. So what was the argument that they ran? The argument they ran to the court says that we thought that we were solvent. They said, we thought that we were solvent. And part of that was because he said we didn't know about the debts. But the court said that's not the test. And if we go back to 588G, 588G is, if we look at that final element there, a reasonable person would have grounds to suspect that the company was insolvent. So what we're looking for is whether the director had any reason to suspect that the company was insolvent. And that's instructive because it tells us what directors should do if they have a suspicion of insolvency. So the fourth element there is suspicion of insolvency. So the court in Asic and Plimen, Asic and Elliott, it's the same case. The directors, their defence is saying, we thought we were solvent. The court says that's not the test. The test is, did you have any reason to suspect that you were insolvent? Okay, so it's not saying, the director's argument is, we thought we were solvent, and the court says that's not the test. The test is, did you have any reason? You might have thought you were solvent, but did you have any reason to suspect that you were insolvent? If you have any reason to suspect that you're insolvent, then you must not trade. You must stop trading at that point. And that's instructive because what are directors to do then if they can't trade? Well, what they are to do, and this is where we sort of go from directors' duties into talking about winding up companies and liquidation. We'll talk about a thing called voluntary administration, the VA, voluntary administration, which is where directors put up their hand and say, we have a reason to suspect. We suspect that we might be insolvent. They might even say, just like they did in ASIC and Elliott, they might say, look, we think we're solvent, but there is a possibility that we're insolvent. So at that point, what they do is the company stops trading. They call in an administrator, and the administrator, and they enter a thing called voluntary administration. And the role of the administrator, one of their roles, is to determine whether the company actually is solvent or insolvent. And the administrator might step in and say, yeah, we think you're being cautious, we do think that you're solvent, and they may continue to trade. Or they might say, we think you're insolvent, and then they can either enter what we call a deed phase, which is where the administrator runs the company. Subject to agreeing to creditors for giving some debt or something like that, the company can continue to trade, or the company is wound up. But for our purposes, we're considering the duty to avoid insolvent trading. So if directors have a suspicion, have any reason to suspect that they are insolvent, then they must stop trading at that point. They must cease trading, even if they think they are solvent. If they have any suspicion, they must stop trading. And that suspicion of insolvency, it's another area that can be a little bit tricky to sort of determine at what point company directors suspect or have a suspicion that they are insolvent. But again, what sort of clues will I be giving you? It'll be things like if the directors are given a report by the chief finance officer or something like that, that says there's cash flow problems, there's insolvency issues, we don't think we're going to be able to raise capital, then that suggests insolvency, and it suggests that the company directors knew or had a suspicion that they were insolvent. Now, what's interesting about this last element, the reason to suspect insolvency, is that if we have a look at 588H, we see the defences to insolvent trading, and you'll see that one of the defences is that the directors thought that they were solvent. The courts have not allowed that, and that was illustrated in the Metropolitan Fire Systems and Miller case, and the courts basically said we can't reconcile the fourth element of 588G and the defence at 588H. So yes, it applies. Yes, it exists, but it's hard to see where the courts would actually accept that. It's almost more like a factor that if you can't point to something specifically that says, look, you know, we can show definitively that the directors have a reason to suspect insolvency, then you can then say, well, they thought they were solvent. So if you can't point to why they might have suspected insolvency, then that may be where it applies, but we're yet to find out. Okay, so those defences. Let's have a look at some of these defences in a little more detail. So we've seen that one. Let's skip over to this one actually. The Southern Cross Interiors case. In this case, we've got Mr. and Mrs. Clark. And so the reason for mentioning this case is quite interesting. This case, it reminds me of the Armadio case. Remember doing Armadio in commercial law, or Garcia in commercial law, those contract law cases. The facts remind me a little bit of those cases. But this case, the court finds against the weaker party as far as corporate law goes. So if you have a look at here at the facts, we've got this company, Southern Cross Interiors. It's husband and wife, Mr. and Mrs. Clark, are the directors of this company. It was a carpentry business that they ran. The company became insolvent but continued to trade, so it was insolvent trading. The court, or ASIC, sought to prosecute Mrs. Clark, saying that she had traded whilst insolvent, and her response was that she had very little to do with the running of the company, and that she was basically, she said, look, my husband does everything. He just would hand me documents to sign, and I would just sign them. And there's that quote, I'd usually have a frying pan in one hand and be signing with the other. And her argument was that she was a director in name only. She had very little to do with the running or the management of the company. The court, though, said, so she was arguing this almost vulnerability sort of case. The court said that this argument may have succeeded in other areas of the law, so in contract or in equity, but this does not apply in corporate law. And as Mrs. Clark was a director, the court said, therefore, irrespective of what level of involvement she had, she was still liable for all of the director's duties, including the duty to avoid insolvent trading. The next case is somewhat similar. It's the Statewide Tobacco Services and Morley case. In this case, Mrs. Morley, again, was a director of this small family company in name. She said she had no participation in it, in the management, and that it was her son who actually managed the company and allowed the company to trade whilst insolvent. And her defence was that she simply relied on what her son had told her. And just like in Southern Cross Interiors, the court said, that doesn't matter. You are a director of this company and therefore are liable as a director of the company. So just to sum up with the insolvent trading, just remember those four elements that you do need to make out each of those four elements. You need to be able to point to those four elements. The consequences of insolvent trading are that it is a civil penalty provision, but it is also can be made a criminal matter if it's caused by dishonesty. So the remedies are the civil penalty, or the liquidator can bring proceedings, or the creditors can bring proceedings with consent of the liquidator. We talked about 588V last week. And just remember that 596AB says that a person must not enter into an agreement with the intention of preventing the recovery of entitlements, employees' wages, and we touched on that already. So that's the end of that lecture. Let's leave that one there. Just talk amongst yourselves for 30 seconds. I'll load this up. Okay, so let's make a start on this one, and then we'll have a break. So this lecture will cover. So we've touched on 180. We've covered section 180, the director's duty of care. Talked about insolvent trading. So this lecture covers the duty to act in good faith and in the best interest of the company, the duty to exercise powers for a proper purpose, the duties to not to misuse your position or information, and the duty to disclose conflicts of interest. So just remember what I've said on a number of occasions now, that each of the duties is discrete. So when we're considering the for example, the 588G duty, you need to be able to point to the four elements and make those out. The duty of care, you need to point to the Daniels and Anderson case and consider what a reasonable person would do. With each of these, you'll see there is a test, a legal test that you need to apply for each of these. So whilst there is overlap between these, and for example, we looked at the Asic and Adler case last week. In that case, Rodney Adler was found to have breached his duty of care and was found to have acted for an improper purpose, and was also found to have misused his position. That's not an uncommon scenario if you're given a set of facts where something has gone wrong, that there may be several of the director's duties that are in play, that are an issue. But where you do think that might be the case, that there might be several duties that apply, you still need to apply each test for each of the duties. So apply the test that goes with the relevant duty. Because if you can't make out the test, then it won't be a breach. So these are separate things. So be really clear about what the legal test is for each one of these. So we might recover some of the information that we talked about last week, but we'll look at it from a slightly different perspective. So the first of these duties that we consider in this lecture comes from a fiduciary duty. So all fiduciaries have an obligation to act in good faith and in the best interests of their principals. So a fiduciary duty arises where you have a vulnerable party and a party that is in a position of trust. So the typical examples that we cite here, a doctor and a patient. The doctor is in a position of trust and the patient is somewhat vulnerable. So the doctor has an obligation, a fiduciary duty, to act in the interests of the patient. Another example that we use is a lawyer and their client. Again, a position of trust and a vulnerable party. So a director, we would say, is similarly in a fiduciary relationship. A director owes a fiduciary duty to the company, that the director is in a position of trust and the company is somewhat vulnerable to the director. So there is a fiduciary duty that applies, but it has been codified somewhat. So the section 181(1)(a) duty, that the director must act in the best interests of the company, is where that has occurred. So the director must act in good faith and in the interests of the company. So what do we mean when we say good faith? According to Asic and Adler, when we say the director must act in good faith, this means that the director must act honestly. So in Asic and Adler, the court considered it was a breach of this duty where Mr. Adler hid the fact that HIH was funding the acquisition of shares in itself. Adler made out that he himself was behind the purchase, so he was acting dishonestly. So the court said this was a breach of his duty to act in good faith. Now, curiously, the duty to act in good faith and in the interests of the company, that is the one, I guess, duty, which we tend to deal with that all together. The courts have argued that at times that the good faith duty is separate from the duty to act in the interest of the company. So, but we tend to deal with them together. So it's the only one that sort of sits on its own. Again, we ask this question, who is the company and what are the company's interests? So directors need to know when they have this obligation to act in the interest of the company, who it is that they actually owe that duty to. So remember we saw in the Greenhalgh and Ardern case that the court said that the directors must act in the interest of the company as a whole. So the court said that that directors owe their duty to the company that they are a director of, and the company there is the company as a whole, so the entire group of shareholders. And we've seen that there are, without going over what we talked about last week too much, remember that with creditors, the court said there's not so much a duty there, but there is definitely an obligation to have regard to the interests of creditors. And as the company, or if a company approaches insolvency, there's an alignment, if you like, of the interests of creditors and the interests of the company. Now, the corporate group issue, so when we're considering section 181, 1A, the corporate group issue is quite problematic. So remember that the directors owe their duty to act in the interests of the company that they are a director of. So where we've got this holding company and a subsidiary company, the directors of the subsidiary owe their duties to the subsidiary, not to the holding company, unless there's some reason why they are entitled or allowed to act in the interests of the holding company. So section 187 allows directors in that precise scenario, the directors of the subsidiary, to act in the interests of the holding company, provided that it's a wholly owned, 100% owned subsidiary, and the Constitution expressly allows, that's the key, the Constitution expressly allows the directors of the subsidiary to act in the interests of the holding company. And then there's the usual good faith protection and that the company is not made insolvent. So you can't just give all the assets of the subsidiary to the holding company. So section 187 is the key there. Where section 187 does not apply, so where a subsidiary has not actually put that provision in its constitution, there is potentially the directors of the subsidiary still can act in the interests of the holding company. So the test, and this is the test for section 181, 1A. So the test for whether directors have acted in the interests of their company, the section 181, 1A, comes from the Charter Bridge case. But it was applied in Equity Corp. We'll have a look at Equity Corp in a minute. So have the directors acted in the interests of the company that they are a director of? The test is whether an intelligent and honest person in the position of the director could have reasonably believed the decision was for the benefit of the company that they are a director of. So it's really the last few words of that test that's the key for mine. So the test as to whether directors have acted in the interests of the company that they are a director of is there a benefit that flows to the company that they are a director of, and what then is that benefit? So is there a benefit that flows to the company? It's a good-looking diagram up there is the Equity Corp case, which illustrates this point. So a little bit tricky. And Equity Corp is another one of these companies which has been good to corporate law. There's a couple of cases that refer to Equity Corp, or that refer to the same set of facts, actually. So we've got this, I'll just talk through what we're illustrating here. We've got a corporate group called Equity Corp. And there's 3 subsidiaries of Equity Corp that I've mentioned there on the slide, EFSA, EFL and EURES. So EURES had borrowed $200 million from BNZ, which is the Bank of New Zealand. And it had borrowed that money so that it could finance the takeover of another company. So that's on that side of the diagram. On the other side of the diagram, we've got these EFSA and EFL. Those 2 entities actually had money in the bank, if you like, and the bank that they had invested that money in was the Bank of New Zealand. So we've got this curious set of facts where one subsidiary of the Equity Corp group has borrowed $200 million, and the other side of the Equity Corp company has actually invested $50 million in the Bank of New Zealand. When EURES came to borrow the money from the Bank of New Zealand, the Bank of New Zealand said, look, that's fine, we're happy to lend you the money, but we are a little bit concerned about your ability to repay the money. So they said, we will only lend the money to EURES. We've got this $50 million on deposit from EFSA and EFL. If that money can be used to actually pay down the loan. So that's precisely what happened. The issue, though, is the Bank of New Zealand was, its concerns were quite legitimate, and the Equity Corp group collapsed. The Equity Corp group collapses. So what's the issue in the case? Well, the issue is that the liquidator of the Equity Corp group, they seek to recover all of the as much assets as they possibly can to pay out the creditors of Equity Corp. Equity Corp's insolvent, liquidators in place, trying to recover all of the assets, and they come to EFSA and EFL and they say, we're trying to find this $50 million that you guys had. We'd like to use that to pay out creditors. And the directors of EFSA and EFL, what do they say? They say, we gave that money to the Bank of New Zealand. And the liquidator says, well, companies aren't charities. You can't just go around giving away money, certainly not $50 million. So the allegation, I'm being somewhat humorous, the allegation against the directors of EFSA and EFL was that they had breached their duty to act in the interests of the company. Which company? Well, they owed their duties, the directors of these 2 subsidiaries owe their duties to the subsidiary, not to Equity Corp, and they certainly didn't owe any duties to EURES. So the allegation, they said, is you can't just go around giving money away. And so the liquidators sought to sue the directors of these subsidiary companies for breaching their duty to avoid insolvent trading. Now, Section 187 did not apply. Section 187 did not apply. So, who wins in this case? Who wins in this case? The directors of EFSA and EFL or the liquidator? Well, the court found in favour of the directors of EFSA and EFL, said they did not breach their duty to avoid insolvent trading. How did the court come to that conclusion? Well, the court applied this test. Had they acted in the interests of the company, was there a benefit that flowed to the subsidiary companies? Was there a benefit that flowed? And it was somewhat of a theoretical argument that the court accepted. And it does suggest that the question of whether directors have acted in the interest of the company, of whether there is a benefit that flows, is a fairly low threshold. So the court doesn't sort of quantify what the benefit really is, it just sort of asks, is there a benefit? So what was the benefit that flowed to EFSA and EFL? Well, the court said the concern was that if Euros had been exposed to the full amount, was that Euros, just like what the Bank of New Zealand said to them, if Euros had been unable to repay the money, then Euros itself would have become insolvent. And if Euros had become insolvent, Equity Corp Holdings was likely to be liable due to a guarantee that was in place. And if Equity Corp Holdings was called on to repay the money, then Equity Corp itself might be insolvent. And then the argument then was that that would expose EFSA and EFL to any guarantees that they might have had in place, in which case they may also have become insolvent. Now, the irony of that, of course, is that ultimately what happened is that the entire group collapsed anyway. But the court accepted then that allowing this $50 million to be used this way to effectively be given away, there was actually, albeit a theoretical benefit, there was a theoretical benefit to these subsidiaries, that it gave these subsidiary companies the best chance that they had of survival, even though ultimately they didn't survive and they collapsed anyway. The key was there a benefit that flowed to the subsidiaries? Was there a benefit that flowed to EFSA and EFL? The court said yes, there was. Therefore, the directors had not breached their duty to act in the interests of the company that they are a director of. Before we move on, just to note, there's a few other examples where the court has found that there is a breach of the duty to act in the interests of the company, and these are set out in the textbook. In the BCI Finances and Beneta case, the court found that it was a breach to enter into a scheme including lodging false tax returns to avoid paying income tax. That was a breach of the duty to act in the interest of the company. In the Thomas and Arthur Hughes case, it was a breach to transfer assets to other companies controlled where there was no benefit to the company, which is actually a little bit like Equity Corp, but there was no benefit to the company. And in the Kijarina case, which is also in the textbook, it was a breach to transfer real estate from the company to the director's wife shortly before liquidation for no consideration, and no funds were then available to pay creditors. Okay, so that's the duty to act in good faith and in the interests of the company. The key aspect is whether there is a benefit that flows to the company. Just wondering if that's maybe a good time to pause. If I pause there, the clock on the back wall I think is a little bit slow. So if I resume talking at 5 o'clock, according to the clock on the back wall. All right, guys, let's resume. So before the break, we considered, we finished our consideration of insolvent trading, and then we considered the duty to act in good faith and in the interests of the company. The next duty that will come to is the other Section 181 duty, which is the duty to act for a proper purpose. Directors have this obligation. The test, if we start out with that, is a two-part test, is to consider as a question of law, and the test comes, by the way, from the Howard Smith case, which we'll talk about in a moment. So the first step is that the court must ascertain as a matter of law the purpose for which the power may and may not be exercised. So effectively asking why the directors have been given the power, and then determining as a matter of fact the purpose for which the power was exercised by the directors, and whether that purpose is within the category of permissible purposes. And I guess there's almost a preliminary question. So we've got this two-part test, but there is almost a preliminary question, which is just to consider what is the power? What is the power that's being exercised? And then to consider why the power has been given. And so when we say why it's been given, it'll usually be given under the Corporations Act, but potentially be given under the Constitution. Just because it's been given under the Constitution doesn't mean that directors can exercise the power arbitrarily, though, either. So we still need to turn our minds to why the power has been given. It's also worth noting that last point there I've noted on the slide is that there are scenarios, and in most of these proper purpose cases, the argument that the directors that are alleged to have acted improperly, the argument they run is usually that they have exercised the power for a proper purpose. So the question will often be, there might be a number of purposes that you can point to. In a particular set of facts, you could argue that there are a number of purposes or a number of reasons why the director has actually exercised the power. And so the courts have accepted that may be the case, and this comes from Howard Smith. The court there said, well, what was the dominant purpose? What was the main reason that you exercise the power? And that's the court there applies the but-for test, and we'll come to that in a moment. Whilst there may be a number of powers that are called into question, if we look at the cases that have had to consider this issue, the most common power which has been challenged is the share issue power. So the power that directors have to issue shares. That's the one that seems to come up most often in the cases where there's an allegation that directors have acted improperly. So if we look at the share issue power, there are actually several legitimate reasons that the Corporations Act gives that power to directors. So the primary reason being to raise capital. There are other things such as employee share schemes, dividend reinvestment plans and others. So the directors of a company will normally have several powers at their disposal which may have an effect on the control of the company. But the exercise of this power, the share issue power, may be used for improper purposes. So, not always, but directors could actually issue shares for the purpose of entrenching the existing control of the company. So if they issue shares to one particular shareholder, then that just increases that shareholder's control of the company. Yeah, so that would be an improper purpose. Yeah. Similarly, in the White House and Carlton Hotel case, which we'll touch on, the directors actually issued lots of shares to shareholders, but didn't issue shares to one particular shareholder. So it had the effect of diluting the shareholding of that particular shareholder. And it may also be used to discourage a bidder for control, which was really what the Howard Smith case was about. So Howard Smith and Ampol Petroleum, which used to be a chain of service stations in Australia that got bought out by Caltex. So the facts of this case, one of my favourite corporate law cases, I often say, involved Ampol and another company called Bulk Ships, and they made a takeover bid for a company called R.W. Miller. Combined, before the takeover bid, they had 55% of the shares. The takeover bid, or the takeover, was priced at $2.27 per share. The Miller board rejected the offer on the basis that it was too low. There was a friend, if you like, of the company, a friend of R.W. Miller, a chap called Howard Smith. He made a rival bid at a higher price. He made a bid at $2.50 per share. But Ampol and Bulk Ships combined released a statement stating that they intended to act jointly in relation to the future operation of Miller and would reject any offer for their shares. And of course, if those two combined had 55% of the shares and they reject the offer, then any counter bid or counter offer from Howard Smith was also going to fail. The board of R.W. Miller then stated that they needed $10 million to finance the construction of tankers, and it needed capital, it needed money to finance this construction. And specifically, it needed $10 million. So the question was, how were they going to raise $10 million? So they decided to issue shares. So issue shares to shareholders. Shareholders would pay the company. So we're selling shares to the public, and in return, the company receives $10 million in capital. So the board issued 4.5 million shares at $2.30 each. Now, did the board issue shares to all shareholders, or at least offer the shares to all existing shareholders, or go to the public? No. The board issued shares to one shareholder. Who was that shareholder? Howard Smith, yeah. What was the effect of issuing 4.5 million shares to Howard Smith? Well, remember that prior to issuing these shares to Howard Smith, what was Ampol and Bulk Ships combined holding? They had 55% of the shares. After issuing these shares to Howard Smith, Ampol and Bulk Ships holding fell to 36%. 36% of R.W. Miller combined. Now, I should mention, later, of course, we're going to talk about takeovers. So this is a 1970s case, so the law in relation to takeovers has changed quite significantly. And so there are actually a few aspects to this case that, if we looked at it from a takeovers perspective, is actually would probably be a few other breaches. In fact, the arrangement by Ampol and bulk ships to operate together would now be a breach of the takeover provisions, most likely. But anyway, let's put that to a side and focus on the director's duty. So the question is here is that, of course, Ampol and bulk ships weren't too happy about the board of R.W. Miller acting the way that they did, and so they sued the board for a breach of their duty, the director's duty to act for a proper purpose. So just summarising the facts, the board of R.W. Miller issued these shares. So that's the power that was in question. What was the argument by R.W. Miller, the board? They say, why did you issue these shares? What did the board say? Well, they said that they needed capital. They said, we needed to raise capital. We needed $10 million so we could fund the construction of these tankers. And the argument, though, was that the board had issued these shares so as to dilute the holding of Ampol and bulk ships. Yeah. So what does the court find? Who does the court find in favour of here? Does the court find in favour of the board of directors or in favour of Ampol and bulk ships? The court found in favour of Ampol. The court said that the share issue power had been exercised for an improper purpose. So what's the power? The power is the share issue power. Why does the Corporations Act give the power to directors to issue shares? Well, it is to raise capital. That is the primary reason that companies' directors have the power to issue shares, is to raise capital. But then applying the second part, remember our two-part test, so legally why do they have the power? Factually, why has the power actually been exercised? The court looked at the facts, the court looked at the events prior to the issue of shares and said, look, we know that there was a takeover offer on the table and that you were not particularly happy about the takeover offer. The court found that it was somewhat interesting that the board of R.W. Miller had decided to issue shares to one shareholder. So the court said that suggests that there were other reasons for the board exercising the power. And another aspect that the court noted was that the fact that they had sought to raise capital by selling shares, the court said, look, if you needed to raise capital, why not just borrow the money? But instead you sought to sell shares, which manipulated or entrenched control of the company, or diluted control of the company, really. And the other aspect is that when the company was perfectly able to borrow the money, if you did borrow the money, any interest repayments would be a tax deduction, so tax benefits in borrowing the money rather than issuing shares, which you would likely be paying out more dividends without getting any benefit for, and in fact giving up control. So the court held that even though the directors were not motivated by any purpose of personal gain or advantage, their substantial purpose was not to satisfy any need for capital, but was to destroy the majority holding of Ampol and bulk ships. So the board of R.W. Miller argued that it needed more capital, but the court was not convinced that this was the dominant purpose. So the court sort of applies this two-part test, and then it says, look, even if we say that there are mixed purposes, the court has to consider which is the dominant purpose. So the court said where there are mixed or multiple purposes for a decision, in order for there to be a breach of duty, it must be shown that the substantial purpose was improper, and that but for the improper purpose, the directors would not have exercised the power. And that was the conclusion that the court came to in Howard Smith. The court said, even if you argue that there was, the board was acting for a proper purpose and an improper purpose, the court said, but for the improper purpose, the board would not have acted. The board would not have issued the shares. And therefore, the court concluded that it was a breach of the duty to act for a proper purpose. Yeah. We've got a couple more proper purpose cases to work through. The White House and Carlton case is a somewhat ironic case. We've got the Carlton Hotel Company, which was owned by the White House family. Mr. Whitehouse controlled the company, controlled the management of the company. There were three classes of shares that were issued. There were Class A, Class B and Class C shares. So Class A shares were all issued to Mr. Whitehouse, and they had unrestricted voting rights. And then we had Class B shares, which were held by Mrs. Whitehouse, and they had voting rights, but only on the event of the death of Mr. Whitehouse. So Mrs. Whitehouse only had a say in the running of the company as a shareholder on the death of Mr. Whitehouse. And then we have the Class C shares that were held by the children, and they had no voting rights, but they did have a profit entitlement. So what happens in this case? Unfortunately, Mr. and Mrs. Whitehouse separate, and that Mr. Whitehouse is a little bit upset about that, because he's like, oh, well, if I die now, then my wife, my estranged wife, will get to control the company. So what does he do? How does he avoid this? How does he avoid his wife taking control of the company? Well, he seeks to dilute her control. So now he issues more Class B shares. Who does he issue the Class B shares to? He issues them to his children. So his children have now got Class B shares and Class C shares. The children have more Class B shares than his wife, which means that in the event that he dies, his children will now have control of the company rather than his wife. The problem is that Mr. Whitehouse then has a falling out with his children, and his children then side with their mother and his wife. Mr. Whitehouse is particularly upset about that. And so he then goes to court. And what does he argue in court? He argues that the issue of the Class B shares to his children was done for an improper purpose. What's the irony of that? The irony of that is that it was him who had authorised the issue of those shares. But the court did actually accept his argument, and the court held that his issue of shares had been done for an improper purpose. It was impermissible for the use of fiduciary power to create or destroy majority voting power. The court also in that case applied the but-for test There's also the Kokotovic case, which is where there was an issue of shares to the children of the managing director, which, even though there was again an argument that this was done for legitimate purposes to raise capital, it was actually being done to dilute the holding of one of the shareholders. So it was, the court said, but for the improper purpose of manipulating the voting power, the share issue would not have been made. These other examples deal with, I think they all deal with cases where there's an improper purpose, but it's not the share issued power. So in the Advanced Bank of Australia case, a company used funds to conduct a campaign to re-elect several of the directors. Yes, and then in Yuri's case, the board sought to prevent shares being registered to prevent a faction of shareholders who could appoint Mr. Yuri to the board. And in this case, the court held, even though the Constitution allowed directors the power to make a certain decision, it must be exercised bona fide and not arbitrarily or at the absolute will of the directors, but honestly in the interest of the shareholders as a whole. One more case. Yes, the PBS, Permanent Building Society and Wheeler case, which again was an example of a breach of directors' duties. In this case, we have to just sort of follow the money trail. So we start over this side with the Permanent Building Society. Just note the CEO and chair and director of this company, Mr. Hamilton, Mr. Wheeler and Mr. Holding. They purchased a property off another company. The PBS, Permanent Building Society, purchased a property off this other company. It was accepted in evidence that they had paid 2 times what the property was actually worth. Why would they pay double the property's value? We'll revisit that. This other company then acquired, with that money, this company, JCDL, off. That was a subsidiary, a wholly owned subsidiary of a company called Capital Hall. So by paying the money, paying for the property, that allowed this other company to acquire this subsidiary company, JCDL, off Capital Hall. What we need to point out is who controlled Capital Hall. Mr. Wheeler and Mr. Holding, who we see on the PBS side over there. So clearly, when we're sort of looking at it like this, we can see what's going on. We can see that this paying so much for this property, paying double for this property, was so that there was an eventual benefit to Mr. Wheeler and Mr. Holding. So that's the facts of this case, which is set out there. So this was found to be, the purchase of the property was found to be being done for an improper purpose. And so the court there set out 4 principles for an improper purpose. The 4th one is the key one that goes to the but-for test. The court must determine whether but for the improper or collateral purpose, the directors would have performed the act impugned. Yeah. So even though there was, maybe an argument that the Permanent Building Society needed this property, the fact that they paid double, and so the court says, well, but for the improper purpose, would they have acted? And the court said no, they wouldn't have. Okay, so to finish up the section 181, there's the 2 aspects to 181. The good faith and in the interest of the company and the proper purpose. They are very separate. And in fact, they're probably the 2 that are least common to appear together. So be aware of those tests. So the test at 181(1)(a, the duty to act in good faith in the best interest of the corporation, the key test is whether there is a benefit that flows to the company. And then the duty to act for a proper purpose. The test there is the Howard Smith test around that two-part test, and then the dominant purpose test. The test for duty to act in good faith in the interest of the company comes from Equity Corp or the Charter Bridge case. Yeah. Okay, so let's move on. The next duties that we'll cover really relate to sections 182 and 183. Sections 182, 183, so the duties not to misuse their position. So directors' duty not to misuse their position and not to misuse information that they have obtained by reason of their position. Now, those duties, if we were to summarise them, we would say that they relate to conflict of interest. That the directors have duties where they have a conflict of interest. The conflict of interest issue has existed in our law, in the common law, and this fiduciary law for a long time. So there is a lot of cases. So with the section 182, 183 duties, the way that I tend to discuss it is to discuss the background to the common law conflict of interest, and then see how it will apply under the statutes. So if you were considering a conflict of interest case, though, remember what I said last week. We'd still start our discussion by saying directors have a duty under section 182 or 183 not to misuse their position or not to misuse their information. So even though we're giving a lot of background stuff here, just to be aware that's what we're dealing with. Yes. The other aspect actually too, which I should mention, is that the area of conflicts has changed a little bit, and the statutes and the common law probably don't align perfectly, but we'll probably see that the common law has actually changed to reflect the statutes, which is kind of interesting. So the most obvious example of that is the way that we expressed the common law duty was that directors had a duty to avoid conflicts of interest. And that is clearly not the law today. The law today around conflicts of interest is really that directors have a duty to manage conflicts. Conflicts of interest are inevitable and happen all over the place. And if we look at if we were to look at the boards, in particular of ASX listed companies in Australia, you would see that there are lots of directors who sit on multiple different boards at one time in Australia, and there would have to be an argument that at some point there is a conflict of interest. Now, I suspect that the types of conflict are what we would need to consider. I strongly suspect that it would be impossible for a director to be on the board of, say, the National Bank and the Commonwealth Bank at the same time. I would argue that that's is a conflict of interest which should be avoided and could not be managed. But let's use a silly example. What about if a director was to sit on the board of Woolworths, or the large retailer Woolworths? Could they also sit on the board of Qantas, a large airline in Australia? Well, they operate in fairly different industries. But of course, Woolworths has a rewards program for their customers, and the part of that is a frequent flyer program, which at the moment that's provided by Qantas. So would that sort of scenario present a conflict of interest? And I would say yes, it would. But I suspect that it's the type of conflict that probably could be managed, because most often directors sitting on the board of Woolworths or a director sitting on the board of Qantas probably they'd never have to consider issues that relate to the other. But a director on the board of Woolworths, considering their everyday rewards program, if they were sitting on the board of Qantas, would probably have to excuse themselves. And we'll talk about the duty to disclose conflicts of interest probably next week, which comes from section 191. So that's a little bit of sort of background, just to think about the sorts of conflicts. But conflicts arise in a variety of ways. So the general law conflict rule comes from the hospital products case. It was articulated in the hospital products case, is that a director must not be in a position where there is an actual substantial possibility of conflict between a personal interest and the director's duty to act in the interest of the company unless the permission of the company is obtained. So that is already an evolution of the common law, that you can seek the permission of the company. So when will we sort of identify a conflict of interest? So we've said that directors owe a duty to act in the interests of the company that they are a director of. But if you can identify some other interest, which might be a self-interest or the interest of a third party or the duty to another, then there may be a conflict of interest. The United States case suggests that the subjective motives and intentions of the directors are not relevant. It doesn't matter that you intended for there to be a conflict. It's just a question of whether or not there is. But as I've set out there on the slide, so there's a number of different scenarios where conflicts of interest may arise. So directors enter into contracts with his or her own company, making personal profits as a result of his or her position as a director, misusing confidential information or potentially working for a competitor. So let's look at an example of the first one of those, is the Aberdeen Railway case. In the Aberdeen case, Aberdeen entered into a contract. Aberdeen was a company which entered into a contract to purchase equipment from a partnership. One of the directors of Aberdeen was also a partner in this partnership that they were acquiring equipment from. And the court said that the conflict was that the director's personal interest was to have the partnership sell the equipment to Aberdeen at the highest possible price, but his duty to act in the interests of Aberdeen impose on him the duty to obtain the lowest possible price. So directors need to be alert to direct and indirect interests. We'll come to section 191. All right, let's have look at another example of conflict of interest. So the State Bank of South Australia case and Marcus Clark, more recent case. Interestingly, this case relates to the same set of facts as what we were talking about earlier, the Equity Corp case. Marcus Clark, who's not the individual that the street's named after up the road there. Marcus Clark was the managing director and CEO of the State Bank of South Australia. And remember what I said a moment ago, there's nothing wrong with having conflicts of interest. It's about how we manage them. So he was the CEO of the State Bank of South Australia, and he was also a director of that bank, and he also sat on a number of other boards. What other board did he sit on? He sat on the board of Equity Corp. So Marcus Clarke sits on the board of State Bank of South Australia and the board of Equity Corp. So like I said, nothing wrong with doing that, but do have to think about how we're going to manage that. Marcus Clarke, as a board member of Equity Corp, knew that Equity Corp was in financial trouble. And remember, we saw that it did eventually collapse. So he made a decision to acquire, he made a decision as the CEO of State Bank of South Australia that the State Bank of South Australia was going to acquire another subsidiary of Equity Corp. Yeah, so another subsidiary of Equity Corp. And how much was he going to pay? Or how much was the State Bank of South Australia going to pay? He was going to pay $59 million when in fact the best value of this other entity, which is called Oceanic, was $21 million, so almost 3 times the value. Interestingly, the other directors were not prosecuted in this case. The evidence of the other directors was that there was no question about the acquisition of this company. They were just told that they were going to do it. And certainly it appears the bank paid a lot more than it was worth. And the $60 million was going to be used so that Equity Corp could pay down some of its debts. So once it all came out, what had happened, the State Bank sued Marcus Clarke for breach of his director's duty, his fiduciary duty. And he was found to have breached his duty. So today, this would be considered as a breach of Section 182 or 183 as a misuse of his position. Yeah. Let's look at another conflict of interest, is the Furs and Tomkeys case. In this case, Furs, as I've noted there, conducted the business of manufacturing fur coats. FD&D wanted to take over Furs Limited. We've got an individual, Mr. Tomkeys. He was the managing director of Furs, the company which is the target, if you like, the target of the takeover. And FD&D came to Tomkeys and said, if the takeover goes through, if the takeover is successful, we will keep you on and as an employee of FD&D and financially remunerate you pretty well for the takeover going through. So think about the position of Tomkeys here. He's the CEO of Furs. Then we've got another company wanting to take over Furs. Who does Tomkeys owe his duties to? Does he owe them to Furs or to FD&D? Well, he owes his duty. He's got the duty to act in the interests of Furs, the company that he's a director of. But with this arrangement that if the takeover goes through, the takeover goes ahead, he'll get some sort of benefit. It's almost like he could then be seen to be acting in the interests of FD&D, and that's precisely what the court said, that the court held that Tomkeys had breached his duty by placing himself in a position where his personal interests conflicted with his duty to act in the interests of Furs. When we come to talk about takeovers, we will talk about this precise scenario. What happens to directors of a takeover target, or any employees for that matter, of a takeover target? well, they are required now to disclose, if a takeover goes through, what will be the position of the directors on the in the new well, after the takeover goes through, if it does. Okay. Another example, the Green and Vesterbilt case. So as I've set out there in the slide, we've got Mr Green, who is a major shareholder of a construction company called Vesterbilt, and he was also a senior manager or employee of Vesterbilt. He found out that there was a call for tenders from the Vesterbilt group, and he submitted a rival tender through a company that he had set up called Clara Proprietary Limited, knowing full well that it was lower than what Vesterbilt would submit. And so he was obviously the successful tender bid. And the question then is whether this was a conflict of interest, and the court said yes, it was a breach of his fiduciary duty, and he was required to account for the secret profits that he had made. So that starts us to, we move here into a line of cases which deal with a thing called taking the corporate opportunity, which is where there's an opportunity that belongs to the company and an individual decides to take that for themselves for their own benefits. But I don't think we're going to be able to get through all of that tonight. So I know it's a fraction early, but we might actually leave it there, and I'll finish off this lecture next week. So let's leave it there. So get cracking on your reports. All the best with them. I will see some of you in tutorials this week, and the rest of you I'll see next week. even then it would have informed it.